Okay, we're going to go ahead and close the hearing on AB 387 and open the hearing on AB 480, which is next provisions governing supported decision-making agreements, or now that's relating to written agreements enacting provisions governing supported decision-making agreements, providing other matters properly relating thereto. All right, so go ahead and when you're ready.
Good afternoon, Vice Chair and members of the committee. My name is Homa Woodrum. I have to take a breath before I always say my title, so forgive me. The Attorney for the Rights of Older Persons, persons with a physical disability, an intellectual disability, or a related condition with the State of Nevada Aging and Disability Services Division. It's a long title, but what it means is that I'm allowed to advocate statewide for the rights of Nevadans with disabilities of any age and persons over the age of 60. I'm presenting this bill. Assemblywoman Cohen couldn't be present because she's presenting in another committee, so she asked me to step in and assist. The Supported Decision-Making Act is truly an exciting opportunity for Nevada to continue to be on the forefront of disability rights, independence, and least restriction for persons with disabilities. This was presented in the interim during the committee regarding the needs of older adults, veterans, and individuals with special needs. And I think I might have misstated the title, but Assemblywoman Cohen was the chair, and this bill came to light at that time when the discussion veered towards guardianship. I have the opportunity to serve on the statewide guardianship commission and had been asked to present about guardianship in Nevada, and it actually appeared to me to be the perfect opportunity to discuss with the committee supported decision-making based on the efforts of Judge Francis Doherty in the 2nd Judicial District Court in studying Nevada's readiness for supported decision-making and looking at the receptiveness of the community and the community need. And Judge Doherty has submitted some testimony to that effect about that effort. So what I'm going to do is walk through the bill a little bit, but really, in terms of my role, my job is not to speak for persons with disabilities or those who support them. My job is to give them the seat at the table that they rightly deserve. And so I'm really excited about all our wonderful commenters in the South and here in the North, and I'm really looking forward to you meeting them and hearing from them and what this bill will mean for them. So the Supported Decision-Making Act is meant to create a framework that really puts in Nevada law the natural and informal supports that so many of us take for granted. Now, in the social model of disability, we try to look at the fact that persons with disabilities find barriers in society that are sort of man-made. They're the things that we do that exclude them, and that but for those barriers, they wouldn't need certain types of assistance. For example, there's talk of the school to guardianship pipeline, and this is in a report that's forthcoming from the National Council on Disability. And it looks at the fact that sometimes the supports a young adult is experiencing in regarding to schooling and those sorts of things suddenly become an issue when they turn 18. And everyone tells them, you need to go get a power of attorney, or you need to go get a court order or things to continue getting assistance. But why is that? So the Supported Decision-Making Act defines the different types of matters a person could receive these supports regarding: financial matters, support services, their health care affairs. And I want to clarify that the flavor of the support is that the doctor or the educational professional or anybody in the circumstance is addressing the individual. They're not talking to a proxy. They're talking to the individual, and they're asking them what they want and what they need to do. And sometimes that means helping give that person information and resources from people that they trust so that they can make a decision. And what's amusing is that most of us every day use these informal supports. Sometimes we call our mom, or we call our friend, or we talk to a colleague and we talk a problem through. But when you have a disability, sometimes the world looks at that act of asking for help and decides it means you need a greater intervention. And so this act addresses that. So there are by no means an exhaustive list of the types of services that a person could use a supporter to assist them with: legal assessments and advisement, medical services, physical and psychosocial assessments, homemaker services, job decision-making. So really trying to address these categories without being exhaustive or exclusive. A supported decision-making agreement is essentially an agreement between a principal and one or more supporters that enters into the agreement. And right now, under Nevada law, you could enter into a contract like this, but the problem is, how could you make sure that community providers and other individuals would recognize those informal supports? And what we found in talking to hospitals and doctors and other individuals is that they worry about the liability. They worry, what does it mean if I rely on this individual's decision and that with the help of their supporters, at the end of the day, when it comes to informed consent and other legal constructs. And what the bill does is it addresses that particular concern in one of the final sections dealing with, for example, the right to communicate HIPAA-related information, and then also affording them the opportunity to have the decision of that individual treated, even with supports, as if that individual made the decision. And something we find in disability rights is you need to presume capacity. Sometimes people might start to ask questions, oh, I'm not sure if this person is going to be able to make this decision. But really, there's no reason not to rely on what they're communicating to you. And if they need a little help sometimes, that's fine too. So the values, another major provision is on Section 11, where it talks about the values, beliefs, wishes, cultural norms, and traditions that adult holds are what control. So we're not talking about other people impressing their opinions on the individual. We're talking about allowing them to express their beliefs, express their choices, and evaluate information in an informed way. A supported decision-making agreement has to be entered into voluntarily. It has to indicate that the individual who is a party to it understands the nature and the effect of the agreement. It has to be in writing, dated, designate one or more supporters, and designate the kinds of decisions that can be made. And this is really important because we're not talking about carte blanche. We're not talking about a blank check. We're talking about very narrowly carving out the kinds of decisions that you need help with, evaluating information about, and then putting that in a document so that you can get assistance. And people will build supported decision-making teams for different topics. For example, just because I use an accountant to help me do my taxes doesn't mean I lack the capacity to manage my money, and that's exactly the concept that's being dealt with here. So it also talks about the kinds of things the supporter can further assist with: accessing information, helping them obtain information, helping them ask questions, ask the right questions, and then monitor that information. And there's also protections built into the bill about that the supporter needs to be acting consistent with the person's individual wishes. They shouldn't be able at any time to really make a decision independent of the principal. So, and then finally, the bill also provides that nothing in the bill is meant to abrogate the obligations of mandatory reporting or those communications we may have to make sure that somebody is safe. And it's a deceptively simple bill, but it's exciting in its simplicity because what it means is it's creating that final bridge to allow Nevadans to live as independently as possible. And I welcome any questions. And like I said, we also have individuals who have testimony that they wanted to provide.
Okay. Any committee members, any questions? Somebody want to win?
Thank you, Vice Chair. Under the current law, how are these individuals, are they using like a combination of power of attorneys and like guardianships? I mean, I see the need for this for sure, but I'm wondering, how does it currently exist in law?
Homal Woodrum for the record, through you, Vice Chair, to Assemblyman Nguyen. What's interesting is just how people have approached this in different ways. Some people are using the power of attorney for intellectual disabilities for healthcare, and that was introduced in 2015 by Assemblywoman Benitez Thompson, but it's still a power of attorney, and it's still a form of a proxy. And that's something that we don't necessarily want to be continue going down that path because we're trying to put the person in the driver's seat. So some individuals, and you'll hear from testimony, especially in the North, depending on the community's willingness to embrace a supported decision-making agreement, it's actually already happening in Nevada. So for example, the Washoe County School District is using supported decision-making to allow people to stay in control of their choices. So that's, for example, one option. But I have been asked, well, why do we need this law if people are finding these workarounds? But I think that the issue becomes the community acceptance, the cultural acceptance, the ability for hospitals to have a law that they can point to that says, oh, if I honor this agreement, then there's certain protections for me in accepting the choice of this individual. And that's why I think this sort of pipeline to guardianship or the pipeline to proxy decision-making is a problem is because you could go to the doctor and they'd say, well, I really would feel more comfortable if you went and got an order from the court, but that's not necessary and it's not appropriate, and it further takes someone down the path of being told, we don't trust you. We don't trust you to choose who you trust. We don't trust you to make these decisions. So I would say it's a combination of different things. Some people are using supported decision makings just as your basic freedom of contract. You know, you can make an agreement between two parties, but what's interesting is you can't bind a non-party to that agreement. So I could agree that somebody is supporting me, but then we could take that agreement to the doctor, and if the doctor or the dentist doesn't feel comfortable treating me, even with my supporter, then we've hit a roadblock. And how are we supposed to overcome that? This act is meant to address sort of the recognition of supported decision-making in Nevada. And the really neat thing is the outreach that Judge Doherty and her team has done, the outreach we've done with Aging and Disability. People are really excited about this. They're ready for it. And then it is the talking point when we're doing training for providers and training for community partners to say, we know you're worried about this and this seems new, but you're really just honoring the same things you would honor for other people, but without the fear of liability and relying on it.
Follow up? No. All right, any other? Okay, Assemblywoman Krasner.
Hi, thank you so much for bringing this bill. During the interim, Justice Hardesty and I served on a commission together, a committee, and we were talking about guardianships. And while they're so good in so many ways, the question came up, can somebody ever get off of a guardianship, or is this a life sentence once you're placed on one? And that's how this whole discussion came up, and he told me that Judge Doherty is currently implementing this very bill, these decision-making agreements, which they allow someone to have someone help them with decision-making, but they're not the full force of a guardianship, which in some instances people want to get off of a guardianship. They don't want to be on that their whole life, or they don't need to be on it their whole life. So it's not a life sentence. So again, thank you.
Okay, I just have one question. Regarding Section 10, talking about supporters, who do you envision the supporters will be? I just want to make sure that we're not creating an industry of, so to speak, of paid supporters.
Thank you for the question. Homa Woodrum for the record. The question is really valid in terms of who would someone's natural supports be. For some individuals, it's their friends, it's their family. The way that this bill is crafted is meant not to include other forms of support. For example, at Aging and Disability Services Division, we have regional centers that provide certain long-term services and supports to individuals with disabilities, and they do things like have person-centered planning meetings, they help people obtain health care, and this wouldn't exclude, for example, someone from continuing to use those supports and assistance, and it's really meant to address the roadblocks that people hit when those supports are not being recognized. There is not, to my knowledge, any, in the states that have employed supported decision-making, there's not been in the advent of professional supporters, because the concept is really based on who you would trust and who is in your life. But what does happen sometimes, because of the nature of just people's different family lives, is that they may not have the friend or the neighbor and those sorts of things that they would choose to support. So they could select, for example, their service coordinator at the regional center. And again, that person is not meant to make decisions for them. It's somebody who is already provided by the state to help them navigate a particular issue. And I think it really, healthcare is the big area where this comes up for people, especially dental care, interestingly enough. And now the American Dental Association has recently provided guidance that people should not be discriminated regarding their disabilities. But what happens is the cases we get the calls about are, I'm going in for a cleaning or I'm going in for a service and they will not serve me. So the idea would be that this law would allow them to have a supporter such as their service coordinator or such as a friend or neighbor go in and say, I've informed them of the risks, I've informed them what's going on, and and the dentist could be comfortable accepting their consent. And the reason it wouldn't become a paid industry is because everything in this law brings it back to the individual. So nobody would be making that decision for them except themselves.
Okay, thank you so much for that answer. All right, any committee questions? All right, seeing none, we're going to go ahead and have you sit back and go to support on AB 480. If I could have everyone fill the seats, and also south as well. We're going to go ahead and take the first three individuals up north, and then we'll go down south and support. So, whoever wants to go first. Thank you.
Good afternoon, honorable members of the Health and Human Services Committee. Thank you very much for this opportunity. My name is Frances Doherty. I'm a district court judge in the 2nd Judicial District Court in Washoe County. I've served in that capacity for the last 17 years. I've had the privilege of overseeing guardianship cases for many of those years. And in that work and in our additional work as a state through Justice Hardesty and the Commission on Guardianship, we have evolved into certain areas of practice and recommendation that we bring before you today in the form of supported decision-making. This kind of started back in 2012 when the assignment of adult guardianship came to me, and I wanted to examine who are these 1,000 people that we are serving, who are the protected persons we're serving. And we started collecting data for a period of 4 years to break down the age, the placement, the nature of the guardian, where the protected persons lived, and what we found was quite astounding. Because what we found was the number of young people entering our guardianship system equated almost exactly to the number of persons over the age of 60 entering our guardianship system. And I am not sure that that's really, as a society, what we imagine. I'm not sure we imagine that we are protecting, to the extent of complete removal of many civil rights, very young people for possibly a period of decades. Because Assemblywoman Krasner was right. It used to be that it was harder to remove a guardianship than it was to access the guardianship. And it's such a privilege to sit here and say, Nevada is no longer recognized as that type of state. Nevada is recognized as the 3rd most protective state in terms of protecting individual rights of persons who are aged and the rights of vulnerable persons in our state. And that's because of the work that's been done through the Guardianship Commission and with your legislative support last session and this session. And so what we decided to do is look for alternatives to guardianship while we honed and perfected the laws on guardianship. And the most glaring contribution to an alternative for many, many people, a lot of young people, but also others, was this supported decision-making. And actually, it's been around as long as we've been around, right? Family helping family. We have always helped those in our family and in our community who are more vulnerable. But around 1980, Canada actually started a project where those families helping families and loved ones helping loved ones were recognized by the outside community. Because sometimes the barriers to helping your loved one speak for themselves is not always familiar in a public arena. For example, it's much easier for a person to walk in with a service dog to any public location without being questioned than it is for an independent person who may need some support in a public meeting or in an environment to have another person with them. And I will say that even I, in a court hearing, questioned someone who approached the courtroom with the litigant and sat next to the litigant when that person was not a lawyer. And of course, we're about rules and protocol. And so I asked the second person, why are you sitting at the table? And quickly, in my own ignorance and then understanding, realized that the litigant was capable of being in the courtroom, but the support of her mother meant everything to her ability to communicate her concerns. And so we have proceeded on this supported decision-making legislation to ask you to consider, in the work that we've done in the last 3 years, in the tours that we have taken of Nevada, in the hundreds of people we have spoken to in this state about supported decision-making, we ask you now to consider this bill, which is written with all of those citizens in mind. And I'll give you an example of the most compelling couple. In Winnemucca, in one of our presentations, one person walked in to hear our presentation over the lunch hour who was a nurse. And another person walked in to hear our presentation who was a police officer. And it turned out those two public servants had a young child who was turning 18 and graduating. And the last thing they wanted to do is petition for a guardianship for their child, because they knew their child's capabilities, they knew their child's abilities to understand information and convey decisions, but that child had challenges in the world that the world may not have been so easy to accept without their assistance. And because of that couple, because of that police officer and nurse, we forged ahead with this legislation because there are so many citizens in Nevada who don't want to get a guardianship, but who are told to do so because there's no other representation of legitimacy of parents, friends, or families in these public meetings. So I ask you to seriously consider this bill. It's a momentous occasion. We will be only the 7th state in the nation to pass this legislation. It is beautifully written. I will say I've read all the states. This is the most beautifully written, supported decision-making bill. It gives dignity to the principals. It gives credibility to the supporters. It recognizes that the community wants to acknowledge and serve all of the citizens who live here. And it validates the need and the recognition that we are looking for through this bill. So thank you very much for considering my testimony. I will commend your attention to attachment D, which are 2 individuals who we were able to terminate in our guardianship proceeding in 2 separate cases because they had found their way to a supported team who helped them establish housing, employment, financial planning without need or imperative that the guardianship mandate directs. And both of those young men are now living independently, have a supported team, and with this bill, they will have recognition of that supported team in the community if the need ever arises.
Okay.
Thank you very much.
Thank you for your testimony, and I've got Assemblywoman Titus that has a question for you.
Thank you. Thank you for that testimony, Judge. I appreciate your insight on this. And I'm sorry I wasn't here. I had to step out, unless you wanted to hear me cough through a few minutes there. But in any case, as you know, I'm a healthcare provider, and on Saturdays, my paying job is to go to long-term care and see patients. And I have multiple patients there that use this type of services on an informal. They understand they have their capacity. They just can't get out and about, and they need friends and assistance. And in a small community, we all step up. I myself still make house calls and help folks out in this capacity. My concern and my question is, I follow HIPAA laws closely. I can't even have a family member in the room when I see a patient without documenting who was there, if it's okay that they're there, and those kind of concerns that I have. And I just want to make sure that there's no federal laws that would perhaps prohibit some of what we're trying to do there, certainly from the healthcare perspective. And I wonder if you could clarify that for me. Thank you.
Mr. Vice Chairman, through Assemblywoman Titus, this is Frances Doherty in response. I will tell you the majority of the federal laws, including HIPAA, including FERPA, including IDEA, including ADA, the federal laws are where this comes from. The federal laws have been saying for at least 20 years that we need to recognize the individual and civil rights of those persons who have disabilities or are aged. We need to treat them with equality and the civil dignities that each and every person is entitled to. Section 14 of this bill specifically incorporates and references HIPAA, and I can tell you they are hand in glove. This bill is hand in glove with the provisions of HIPAA and will be a wonderful complement to the existing protections that that law offers.
Thank you. And as we finish your testimony, if we can have you vacate the seat, so we have plenty of people in support of AB 480. So if you can sit back, and whoever's next on wants to come up.
Thank you for the opportunity.
Oh, thank you. Proceed.
Mr. Chairman, my name is James Hardesty. I'm a Associate Justice on the Nevada Supreme Court. I initiated and chaired the Guardianship Commission in 2015 and the Supreme Court's Permanent Guardianship Commission thereafter. I want to congratulate Judge Doherty on her work and research. One of the things that our first commission did was support the effort to secure a national grant so that this process could be studied. As her written testimony filed with the committee shows, they made great use of that grant to conduct appropriate surveys and confirm the benefits associated with this process. One of the most challenging things in the area of adult and minor guardianship is the fact that it became a default system because there were no other alternatives, even if people were interested in looking at alternatives. I think this affords a tremendous vehicle to avoid guardianships. Not all of these situations require them. And I am quite confident that many citizens in Nevada who became caught up in the guardianship system could have avoided that if they had had the choice to select the persons that they wanted to receive support from. Vice Chair, you asked a very good question about supporters, and I think there's a key provision in this bill that addresses that issue. The supporters are not those who can prey on the guardians or prey on the protected persons. The supporters are people who are selected by the protected person. Big, big difference. So I urge the committee's support. I'm happy to respond to any questions. I know you have a very busy week. I'll end my testimony with those remarks.
Thank you, Your Honor. And I don't see any questions from the committee, so thank you very much for your testimony. We're going to take one more, and then we're going to go down south for support, so go ahead and proceed.
Good afternoon, Vice Chair and members of the committee. My name is Byron Green. I'm the Chief Student Services Officer in the Washoe County School District, and I'm here on behalf of the Washoe County School District to show our strong support of this bill. We have been working with Judge Doherty for the last several years, and we are the first school district in the country to adopt supportive decision-making voluntarily. There is another district that is using it, but it was under court mandate. We believe that the role as educators is to prepare all of our students to enter the world. And that includes those, especially those students with disabilities. As part of our district, we are looking to support our students to become stronger advocates and be prepared to make decisions. And that's building that infrastructure of support who are selected by the student. Under federal law, under IDEA, it is required that parents are involved within the student's IEP meetings and all educational meetings that involve that student. Once the student turns 18, and if the student does not graduate with a standard diploma, they continue their education until 22 years of age. We want our students to have the support of this decision-making document, so not only are they prepared to have a voice within their IEP, but we're using that as a model to prepare them when they leave our school system. So on behalf of our school district, we strongly encourage the committee to pass this bill. Thank you.
Okay, thank you. And now we're go ahead and we're going to go down south. Whoever wants to go first.
My name is Santa Perez. I am a member of the Nevada Governor's Council on Developmental Disabilities, but today I am speaking for myself. Thank you for letting me speak today regarding AB 480. I would like to tell you about how I got started in my self-directed life. Being in charge of your own self-directed services, not an easy task. But it is one of the important steps a person with a disability will ever take. People that support you will come and go, but after all, it's your life and you are the only one who is going to live it. People with disabilities need to come to the table not as voiceless tokens, but rather as active, opinionated, and confident participants. For people to take charge of their lives, to know their own disabilities, healthcare needs, and not be afraid to ask questions if they don't understand. Important to teach our youth about self-advocacy and self-determination at a young age, so they can self-direct their own lives as they become adults. The more they know about their own disabilities and healthcare needs, the better they can self-direct their lives. The idea is for the person to have a plan for themselves, but always be willing to take others' advice. The providers and the client need to be a cohesive team. They are always able to communicate with each other and to bring other people to help with to create person-centered structure. For instance, I need PCAs to support me. By having self-direct supports, I am able to hire and fire my own PCAs. This includes the ability to choose who I want and feel most comfortable with, which is very important because my PCAs are assisting with the most delicate needs. The reality is not everyone is compatible with one another. I have found that with self-directed supports, the turnover rate is significantly lower and all parties are much happier. I have the flexibility to set my own schedule that fits my lifestyle. When the providers made the decisions about my staff, I felt obligated to adhere to their rules, and even though they were kind, I did not feel like an equal partner in the care of my life. I feel I'm the expert on me. I know what is right for me. After all, I have been living with myself for 56 years. I'm in the pilot's seat and have the ability to make the important decisions that relate to me. It is my hope that you consider approving AB 480. Thank you.
Thank you, Ms. Perez, for your testimony in support of 480. Go ahead, down south.
Good afternoon, Vice Chair and members of the committee. My name is Jim Birchtold. I am an attorney with Legal Aid Center of Southern Nevada, and I head up Legal Aid Center's Guardianship Advocacy Program, which provides legal representation to adults with disabilities and seniors who are facing or under guardianship. Part of that representation is counseling our clients on alternatives to guardianship, ways to avoid the guardianship system if that is at all possible. We see supported decision-making as an invaluable tool to that end. It would allow our clients not only to potentially avoid guardianship, but also to maintain their own independence and maintain their own decision-making ability. So we encourage your support for AB 480, and I'd be happy to answer any questions. And again, thank you.
Okay, thank you for your testimony. I don't see anybody with any questions here. And if there's anybody else in support of 480 down south, if they can take the seats, and if you would like to proceed down up north in Carson.
Thank you. Bailey Bordelin for the record with Washoe Legal Services, which similarly to what Mr. Birchtold just explained in Las Vegas, we represent guardians and seniors in guardianship cases and seniors in Northern Nevada. So as you heard from Judge Doherty, this is something that in Northern Nevada is a model that we have already been utilizing for nearly 2 years. I did have an attorney who was going to come talk about her cases, and unfortunately she had to go to court today. So I will do my best. We want to thank Judge Doherty for being a champion for the rights of disabled and older persons, and we thank her for the ability to allow our office to utilize supported decision-making in some of our cases. It allows for a lesser restrictive alternative to guardianship, And we had hoped to have some former clients come today to tell you about how impactful this has been on their lives, but unfortunately we weren't able to have the time to make that happen. But we want to make sure that you are aware and that I emphasize that all of these people are unique and cannot be painted in broad strokes. This model allows for each person to create a plan that fits their own unique needs. Our clients who have used supported decision making feel empowered in this, and it has changed the outcomes and autonomy of many. We oftentimes in guardianship focus on getting a diagnosis and securing that ability to remove someone's rights, and we feel that this is an important step to focus on what are the functional abilities that a person does have and how can we ensure that that's something that we're highlighting to allow them to continue to live their lives. So we feel that this bill will legitimize and give legal weight and authority to supported decision making and encourage you to support it. Thank you.
Okay, thank you very much for your testimony, and whoever's next, just please state your name for the record.
So hello, Mr. President, and my name is KK, and good numbers. My name is Kelly Brian Kelman, and the people call me KK. I grew up in Reno and graduated from Path to Independence program, and now I live on 11th Street, and I have a part-time job as a pepper cook. I live in a cafe. I set my alarm clock to work every time. And also, I own my business called KK Grass. And I took yoga and cooking class. I do tennis. Next week, I'm going to Special Olympics to California. Yeah, I do this all by myself. But sometimes I need help. I need help to make do my bank account, so I can do my report wages, to do Social Security, and my paying rent, and making my own decisions. So I ask for help. My mom or dad or sister to help me. When I go to a doctor, I like my mom to be there because I don't understand. Sometimes she can explain to me, Dad, I understand better. I need some help. Sometimes I don't need a guardian parent to ask me. Make my own decisions. I'm careful. I need some help. And thank you.
Thank you, KK. And if you could give your, if you have written testimony, if you'd like to submit that to the secretary, that way they can put it in the exhibits. And thanks for your testimony. And whoever's next. And also if there's anybody else in support, if we can go ahead and fill those seats so we can get people to, there we go. Thank you so much, KK. Go ahead and proceed.
Hello, Assembly. For the record, my name is Travis Mills. I have an intellectual disability. With my disability, I'm able to drive on my own, have a job, and take my own medicine, live independently, make my own decisions. And my mother and father and brother are very supportive of me. I depend on my family members to give me advice. This bill will help me give my family members access to bank accounts, state agencies, medical records, and doctors. Thank you for, please support this bill. Thank you so much.
Thank you, Travis. And again, I'll also commend you on being able to testify today. It's really greatly appreciated. If you can submit your written testimony to the secretary so they can put it in the exhibits.
Okay,
all right?
thank you.
Thank you.
Thank you.
All right, whoever's next.
Good morning, Mr. Vice Chair and committee members. My name is Mary Bryant, and I'm the very proud mother of Kaylin and Eilish. You just met Kaylin. I wanted to speak to you about how important supported decision-making is to families like mine. Kaylin was our first child, and my husband and I knew very little about Down syndrome or babies in general. We met other families with Down syndrome, who had kids with Down syndrome, and it became apparent to us that those that weren't babied and that were expected to act normal were the ones that were being the most successful. So Kaylin was soon joined by her sister Eilish, and we had high expectations for both of them. We even did prepaid college tuition for both girls. We made sure Kaylin was included in general education throughout school. She never worked at grade level, but she did absorb some academic concepts, as well as, most importantly, social skills that she learned. She learned how to act like the other kids, which is good and bad. Once out of high school, she attended the Path to Independence program at UNR, which she mentioned. It's an inclusive 2-year non-degree certificate program for students with intellectual disabilities. She took courses such as sociology, women's studies, community health science, karate, swimming, and weightlifting. During her time at UNR, she lived in a house with 2 other students who had intellectual disabilities. And this was really a frightening thing for me as a mother. And as with most college students, there were good decisions made and bad decisions made, and she learned from them just like any college student does. She's very good about asking for help and when she really needs it, and she really matured and decided she wanted to live on her own without roommates. So now she has an apartment by herself, and as she said, she works at Laughing Planet, still has all 10 fingers, even though she's a prep cook. I probably couldn't do as well. And she uses her alarms on her smartphone to get her places on time. She does have an intellectual disability, so some things are harder for her to understand and to learn. She asks us for help when she needs help, and then we help her learn how to do things. I used to report her wages to Social Security every month, but now she has an app that I don't know how to use that she can report them on. And she also pays her rent through the Venmo app. So good thing I have all these apps. When it comes to medical issues, she really looks to us to help explain things differently than the doctor might. So if the doctor is very good, but sometimes she'll look to us and to make it a little simpler. And we've become really good at explaining it in terms that she would understand. We've been really fortunate that she hasn't had any health issues since she's been an adult. But my fear is, as many of our friends, that physicians won't want to perform any kind of a procedure on her if she doesn't have a guardian. Having Kaylin in our lives has enriched our family more than I can tell you. When she was born, I was a gaming executive, as was my husband. Now we're both in nonprofit and work in the disability field. I've served as the chair of the Governor's Council on Developmental Disabilities, and I'm currently on the Permanent Guardianship Commission. So that's been, I'm really excited to be able to be involved in this. And my daughter Eilish is starting her MSW at the university so that she can also impact people's lives. Supported decision making is probably not appropriate for every person with an intellectual disability, but it'd be really good for our family and many families like us. We encourage you to support the bill, and thank you. It will help Kaylin have a meaningful and independent life.
And thank you for everything you do in our community as well. Whoever's next, and if we can fill that seat in support of AB 480.
Good afternoon. Thank you, Vice Chair and committee members. My name is Nicole Schomburg, and I am a member of the Nevada Commission on Services for Persons with Disabilities. But I'm here today in my role as a parent of an adult daughter with Down syndrome to ask for your support in favor of AB 480. AB 480 establishes the Supported Decision-Making Act, which authorizes an adult with a disability to enter into supported decision-making agreement. So, Homa already covered all that. My daughter Heather is a 30-year-old, very independent young adult. She graduated in Reno from Earl Wooster High School in 2008, where she was homecoming queen and modeled in the senior fashion show. She is currently employed as an independent contractor for Paul Mitchell Beauty School. Heather loves all facets of the fashion and beauty world. She collects handbags and has her nails done regularly. She's a superstar dancer with the notable music therapy program in Reno, and that is where she met her boyfriend and now life partner Mike in 2011. Heather enjoys a full life and is her own legal guardian, but she regularly communicates with her parents and her siblings and tells us her preferences, her dreams, her hopes about her life, her home, career, community involvement, health, and social life. And from time to time, she may request from her family support in making some decisions. The Supported Decision-Making Act, as proposed in AB 480, will give Heather the ability and the right to make her own decisions with support as requested while maintaining as many decision-making rights as possible. In 2013, Heather had an abscess tooth. And as you know, an abscess tooth is a painful infection at the root of a tooth. And the dentist recommended that the tooth should be extracted. The dentist felt that Heather would benefit from having the tooth extracted during outpatient surgery under general anesthesia. Heather agreed that she did not wish to be awake for this procedure as it caused her a lot of anxiety. She was experiencing a lot of pain and wanted to have the tooth removed as quickly as possible. While working with the staff at the dentist's office to schedule this procedure, we were told that the first possible date would be at least 5 months out. We were told that because she was her own guardian, that only one facility in town would honor that, and that there was only one anesthesiologist in Reno that would work with an individual with an intellectual developmental disability that has their own guardianship. We were devastated that she was going to have to wait that long. I just had no idea that that could be the impact of her having her own guardianship, basically. As a result of this experience, in 2015, I provided testimony in favor of AB 128, and that was what provided legislation that created the simplified, durable power of attorney for healthcare decisions, and that was more widely accepted by physicians in our community. So in closing, I just ask for your support in favor of Assembly Bill 480. This and like the Assembly Bill 128 really helps our family to support Heather. The supporting decision-making act will help my daughter Heather get the help she might need from a trusted family member and making some decisions without depriving her of her own legal right to make choices for herself. Thank you for your valuable time and consideration.
Thank you, and if you wanted to submit your testimony to the secretary, that way they can put it in the documents, and go ahead and proceed, unless
Thank you.
they already have it, I'm assuming. But
Yeah,
thank
they
you.
do have that. I did submit that. Thank you.
Thank you.
Thank you, Mr. Vice Chair. Eric Jimenez for the record. I was here last week testifying on the need to make sure that people with disabilities have the same economic freedoms as everyone else, and I think through our guardianship system, although well-intentioned, we've seen, a lot of people fall through the cracks when it comes to reproductive freedoms and financial rights and economic rights. And that's why I'm here to testify enthusiastically in support of AB 480 insofar as it will allow people with disabilities to move up. As I mentioned last week, people with disabilities in our state are 2 times more likely to be impoverished and 2 times more likely to be unemployed. We're hopeful that this will help people earn at least the minimum wage, and insofar as that can help them start their own business, like my friend Jack over there, and live their life to the fullest. I think this is a very good bill. Just want to give a quick shout out to my good friend Homa Woodrum, who I believe is one of the greatest advocates for people with disabilities in this state, and we're incredibly lucky to have her. So thank you for all your work on this.
Thank you, Mr. Jimenez. Go ahead and proceed, and thank you for filling the seats.
Good afternoon, co-chair and chair members. I'm here actually 2 seats. I have a brief statement my son has asked me to share with you today. He was not able to attend the meeting in person because he is in class at UNR at the moment. So in a very rushed few moments before he went out the door this morning, he dictated to me what he'd like to say. And it does sound rushed, and I'll clarify that in a moment. My name is Ian Zahner. I live in Reno, and I go to UNR. I have Down syndrome, and I get services from Sierra Regional Center, Vocational Rehab, and the Path to Independence program. My mom helps me with my money, and she helps me make decisions about my health. The Supported Decision-Making Act, AB 480, is important because if I were in a situation where I was unresponsive, my parents would be there to help me make decisions about my health. I strongly encourage you to pass this bill for me and for other people with disabilities. Thank you for your time. I didn't get an opportunity to clarify that the bill had nothing to do with decisions when he was incapacitated, but we'll have that talk when I get home. He wanted to be sure his voice was heard, and I think that's the important thing that I wanted to be sure to share with you today. And then on my behalf, my name is Marcia O'Malley. I have worked and advocated for our disability community for over 20 years. Guess why? Ian is my why and my inspiration. He turned 21 this year, and he is finishing his last semester up at UNR. I'm here today to speak in favor of the Supported Decision-Making Act. And this is why. Since Ian was very young, we have encouraged him to speak up about anything that was important to him, and if you know him, you know that he doesn't hesitate to tell you. He presented PowerPoint slideshows and set his agendas for all of his IEP meetings since he was probably about 10 years old, and he decided who to invite to those meetings. And now in college, his program at the Path to Independence is all about person-centered planning. So he's been surrounded with this process his whole life. And now that he's heading out into the world away from the security of this support system, I worry about his future. And what mother wouldn't? Ian is his own guardian. My husband and I have raised Ian to be fiercely independent. And as any of you who are parents know, that comes with unexpected consequences. Our vision for Ian has always been to support his dreams. And now he has entered adulthood. We're grateful that he still asks for our advice. But it hasn't always been a smooth transition. And I'm sure it won't continue to be. There'll be challenges. But with limited legal options, we've put some protections in place to ensure his health and his safety. Two experiences I feel are relevant to our discussion today about supported decision-making. First, about a year and a half ago, Ian was prey to internet fraud. Now, because he agreed to have me as a co-signer on his checking account, and because we had become very friendly with the manager of our bank, we wound up catching it before there was any big disaster. But it was literally a day away from drawing down his entire bank account. It was a very close call, but if Ian had not agreed to this level of support, I hate to imagine what could have happened. And it's also a situation that could happen to any of us. Today, internet fraud is fairly rampant. I was glad to have been there to help protect him. And now that he's an adult, he's responsible for his health care. Most of the time, he renews his prescription in a timely manner and lets us know he needs to pick it up from the pharmacy. But on occasion, he forgets. And there have been times when he's gone for over a week without his daily dose of medication because of forgetting about it and not notifying us. That's a concern. Another thing that I discovered that's been frustrating is that Ian now needs to make his own doctor appointments. I can't, as mom, make those phone calls anymore. So until he does and gives permission for me to have access to his medical records, I can't help him on that level. So very recently, just about 10 days ago, we sat down and with the help of his supported living assistant, made appointments with 3 different physicians. He has some health concerns that really need to be addressed right now. So I was really pleased that he allowed us to support him with that. And he also asked us to attend his appointment that he had last week. So things are improving, they're changing, and I'm happy to say that that's the direction that we want to see it maintained. So these are just 2 examples of how we have formalized our relationship with Ian so that we can provide the support he needs to make those informed choices about his life. It would be so much better if we had a law in place that encompassed all aspects of supported decision-making for independent living, so it wasn't this piecemeal, we'll fix it here, we'll fix it there, and when something else comes up, we'll fix it there. As a parent, I would feel more confident that Ian would get the advice and he would get the help he needed at every pivot and every turn of his life. As Ian recently reminded me, his father and I will not always be here. So he needs to be able to make it on his own and find the support from others too. He's poised to move out on his own this year, and I have all the typical fears that a mother has in that situation, but my fears also run deeper because I know my son needs more support than his typical 21-year-old peer. So please pass AB 480 so that Ian and thousands of other adults with disabilities here in Nevada can get the support they need to live as independently as possible and help them get that help from a trusted friend and a family member. Thank you.
Thank you, and whoever's next, if we can continue to fill the seats.
Okay, I'm Dick Mills, and I'm Travis Mills' father that spoke a little earlier, and I'm very proud of Travis's accomplishments. In the past, I've spoken to my attorney about guardianship for Travis, and he's suggested that guardianship was too restrictive for Travis, and has advised us against that in the past. AB 480 would allow Travis supporters better access to his finance, banking, federal and state agencies, insurance, doctors, and medical appointments. Most of these agencies are cooperative but require lots of time-consuming paperwork. And AB 480 would help with that. This bill would allow us to provide better research and present different scenarios to Travis. And with this help, Travis is capable of making his own decisions. Thank you.
Hi, my name is Jack. I am 20 years old. I work at Mod Pizza. I have my own small business selling popcorn, Jack's Popcorn Company. I'm UNR student, and I'm doing internship with a dresser office with Zach. I live with my parents, and I have 4 sisters. I like being independent. I like doing things I want to do. My parents and my sister help me sometimes. This bill will let them help me, but still let me do the things I want to do. I will be the boss of me. Thank you. And I want to add a few more things. And I have many popcorn, a lot of flavors. Just if you have a question, just ask me. Just put on Facebook. Just follow me. Anything you want. Okay, that's it. Thank you.
Thank you, Jack, and now's the best time to plug yourself, so thank you. All right, if we can, whoever's next.
All right, good job, Jack. Thank you, Mr. Vice Chair. Members of the committee, my name's David Ravetti. I'm Jack's dad, and ever since Jack started school, my wife and I have the goal of for Jack to be happy and to be independent in his adult life, and so far it's going well. When Jack turned 18, we decided not to put him in a guardianship arrangement. We felt that was kind of demeaning to him and also against our struggle to keep him independent. So this bill would allow my wife and me to support Jack's decision-making, and not really be in total control of it. Things like his medical, his financial affairs, and his living arrangements. Now, when my wife and I are no longer around, Jack's 4 sisters could, and at this point, have agreed to do the same. We don't want Jack in a guardianship. His sisters don't want to put him in a guardianship, and Jack does not want to be in a guardianship. And it would make the life for us much easier if there's a way for us to get help to Jack and still get some legal protection and legal authority without that guardianship. This bill would do just that, and I thank you for your support of it.
Thank you. And anybody else that has any testimony on, then go ahead and proceed, and go ahead and go when you're ready. Somebody flip a coin.
Hi. Hi. I'm excited to come here today. I am better at writing stories than speeches, but I will try my best. I am Logan Mason. I am 19. I go to Worcester High School. Next year, I want to go to the path to independence at UNR. I have lots of health problems. I need a lot of support to stay healthy. A lot of people help me decide things. I am learning to do things on my own more. I do my own tube feeding at school. I have an app on my phone for my wheelchair. I voted this year for the first time. I want to keep learning. I think shared decision making is a good idea. Thank you.
Thank you, and I think you did a great job in testifying, and so don't stop. Thank you.
Hi, I'm Sherry Mason, and I am Logan's mom. It's the first time he's ever really spoken publicly, so that was pretty exciting. So our story with Logan is a little bit different, I guess, and why we're here today. When Logan was born, he was born pretty healthy, but he started to get sick at an early age, and we found out when he was about 1.5 years that he had a primary immune deficiency disease. It's a pretty significant health condition, and it requires intravenous infusions every 2 weeks of other people's antibodies. As he grew, he developed other health conditions, and we found out through genetic testing he had some other health issues. And when he went into school, we eventually learned he had an intellectual disability. So we have lived a lot of our life in the healthcare realm, including a lot of it at Stanford and Lucille Packard Children's Hospital. And as Logan became older, it was a huge fear of mine as to what we would do when he became 18. Because as somebody already pointed out previously, physicians and the medical field are incredibly strict about who accesses information and how things are navigated in those systems, and it's very hard. And so we did take the advice of our special needs planner, and we did establish guardianship for Logan, limited guardianship for healthcare. And that is where we have been for the last year. And we have been waiting for this legislation to come along. And when Logan had an attorney assigned to him, that's what I told that attorney is we're waiting for something a little bit more legal. And we need something a little bit more firm than we're just sharing decisions, because the healthcare field doesn't care about that answer. They need a little bit more. The state of California doesn't really recognize shared decision making at all right now for us. And we're still in a quandary for that. But I can tell you our family does recognize it. And Logan, 3 weeks ago, had a surgery that was 8 hours long. And the first thing I asked Logan before we thought about doing that was, is this something you want to do? And let's talk about why and what the benefits are and the risks and the challenges of doing this. And I think he has always been one that we include. We share decisions all the time. It's a natural thing to do. Logan asked me what would happen if something happened to Rob and I and we weren't his guardians anymore. And he said, won't that be Hunter, his brother? And I said, no, that's not how guardianship works. Hunter would have to go back to court and get the guardianship. And in the meantime, I don't know what would happen. But with a bill like this, immediately Hunter could step in and he could be Logan's shared decision maker. Or if there was somebody else Logan chose. But it would be a lot less complicated for us. And we're very excited to see this come forward, and we hope that other states, as Nevada comes on board, that other states will embrace this for us. It's so important. Thank you.
Thank you very much. Do we have any questions, committee? Okay, seeing none. Okay. Go ahead, Assemblyman Thompson.
Thank you, Madam Chair, and welcome back. I just wanted to say I'm so pleased to hear the testimonies today, and I want to say KK, Logan, Travis, and Jack, and definitely the parents. See, you laughed. I like that. You know, we were listening, and it makes me think of my aunt who's no longer with us, and my cousin Ogita, she and my aunt Barbara, and they had the most impeccable work ethic that you could ever imagine, and I hear that in all of the testimony today, and I really appreciate the parents for helping to be the advocates and supporting, because that is so important. That keeps them all going. And so I just want to say that for the record, and hopefully I'm speaking for some of our members here as well, and just appreciate it and just keep plugging away. Thank you.
Okay, and is there anyone else in support? Okay, seeing none, we will move to opposition. Is there anyone in opposition? Okay, seeing none, is there anyone in neutral? Seeing none, would the presenter like to come back up and make any concluding remarks?
Thank you, Assemblywoman Cohen, Homo Woodrum for the record. Just echoing everyone's comments as far as just truly appreciate everybody coming down here. Ms. Perez in Las Vegas, this is truly exciting and we appreciate you taking the time to hear the bill. Thank you.
Thank you very much. And with that, I will close out the hearing on AB 480. And we will open our work session. Ms. Lyons, please. Or actually, we'll give people a chance to vacate before we start.